Dear friends, this video is going to be dealt with what is meant by constitutional morality at this given point of political climate, wherein the BJP government is steadfastly tilting towards authoritarianism from democratic principles, values, and norms, and damaging all the constitutional institutions, exclusively the judiciary and its constitutional morality, ethics, and values that have been enshrined in the pre-independent India into the ethos of the Constitution. In the Constituent Assembly, Dr. B.R. Ambedkar, Minister for Law in the Government of India, declared that constitutional morality was far more important than that of the Constitution itself. He further added that a constitutional morality is not just a natural sentiment, it has to be cultivated. We must realize that our people have to learn it. Democracy in India is only top dressing on an Indian soil, which is essentially undemocratic. The point made by the chief architect of the Indian Constitution, Baba Sahib Ambedkar, is that the constitutional morality is more important than that of the Constitution. Means all the people and all the lawmakers, all the executives, including the judiciary, and every section of the society must abide by the Constitution and, more importantly, to the constitutional morality. But the government of India at a present point of time as damaging many institutions, exclusively the judiciary. In order to understand what is meant by public morality in the case of the Young Lawyers Association versus Kerala State, which was held in a constitutional bench held by the then Chief Justice of India, Ranjan Gogoi, and held that entry of women at the age of 10 to 50 shall be allowed to have access to the Sabarimala temple, and they should be permitted to worship as others are permitted to worship their god or goddesses. But after that, stiff opposition from the Congress party, particularly from the BJP party, which is not at all accepting any progressive movement on gender issues, particularly women issues. The Supreme Court of India has been forced to hand over the case to a 9-member constitutional bench. What has happened in a 5-member constitutional bench is that only one member out of 5 has given a dissent order, whereas others have given a majority order in favor of the gender justice for women to enter Sabarimala between 10 to 15, but it was quite opposite got from the parties, that is the BJP party and also the Congress local leadership, but the central leadership has accepted the verdict in favor of the women. But after that, it has endorsed the local congressman so as to get a millage, that is political millage in this case. Our point is that the first time in the history of the Constitutional Court, a sensitive case has been dealt with severity that the gender issue must be adhered according to the constitutional values, constitutional morality. The point here is that under Article 25 of the Indian Constitution, that is, which states religious freedom and religious denominations and practice of religion, everything is there. But public morality is nothing but constitutional morality. Exclusively one section of people from worshipping their own god or goddesses is unconstitutional. That was the constitutional position held by the 5 members constitutional bench. Now it has been referred to 9 members constitutional bench. The another point is that in Puttasamy, K.S.PUTTASAMY retired versus Union of India, 9 members constitutional bench. And the court once again was of the opinion that the requirement of the constitutional morality that the government not to act in a manner that violated the rule of law. It was emphasized that the requirement of constitutional morality that the state, that the union government or state government must not act against the orders of the constitutional courts. On various occasions, the government of India, exclusively the BJP government, bypassing all the constitutional court's orders. The point herein is that even in the KESAVANANADA bar, the 13 members constitutional bench, it was held the basic structure of the constitution shall not be even altered by the parliament. That is secularism, socialism, rule of law, federal government, parliamentary form of government, and fundamental rights, and many other things have been held in the KESAVANANADA bar case. But the government of India time and again is raising a lot of questions in the Supreme Court of India, which was already settled by the 13 members constitutional bench. This goes against the constitutional morality. This is the message of this video. Thank you so much.